Time is 8:48. I'm in front of the courthouse. It's the morning of 10:10. I have put together an information packet for the psychologist whom I will be seeing shortly, within an hour. And the packet is self-explanatory if you look at the cover sheet that I will be asking the forensic psychologist to sign. I'm doing so for her safety and her awareness in an assessment that she is making, as well as for my safety in being sure that she is informed with a degree of due diligence in her tasking to determine and make an assessment if I am competent in terms of understanding the object and nature of the court proceedings over a misdemeanor charge, which I am contesting and I wish to self-represent in. The reason I wish to self-represent is really quite clear if simply this documentation is read, because it shows that people have misrepresented me in the past, inclusive of people who are in positions similar to this lady's position. And so I want to be sure that she is aware that misconduct has already occurred stemming out of and from the federal government and the state of Maryland. And it is conduct that further has not been remedied in terms of the right to remedy when injury is apparent, inclusive of injury described in law as theft by extortion. Injury described in law as torture, and injury described in law as conspiracy against trade and imparting and conveying false information, denial of rights such as habeas corpus rights, when there's clear documentation that there's property that the government received and has not paid fair market value for. But it's a long story. This basically is just to make a documentation of the package of information that the forensic psychiatrist will be given. She told me to bring the information. I went early and saw her yesterday prior to this meeting to tell her that I had information for her, that I was clearly competent in terms of understanding the object and the nature of the court proceedings and dealing with this misdemeanor charge. But though it may be a misdemeanor charge, I am contesting it by right of law. I am asking for a jury by right of law. I am stating that I wish to self-represent by right of law and right of, well, a defendant is presumed competent in law unless there's reason to presume otherwise. And there is no reason to presume otherwise, since my actions have been totally coherent and legitimate all along. So in the beginning first paragraph, the forensic psychiatrist has said this examination was ordered due to odd or bizarre behavior, problems understanding or following procedures, and problems cooperating with attorney. So, number one, he's still not my attorney, okay? Because I've asked to self-represent. Number two, this woman has said, due to odd or bizarre behavior, problems understanding or following procedures. And yet nobody's allowed me to, and nobody's tried, and I'm challenging anybody to show that there is no presumption, that the standard of presumption of competence has been breached on the record. In fact, all I've asked for are rules of due process, rights of mine, the right to self-represent, the right not to be saddled with a lawyer who is not my lawyer, but who people are trying to throw and force on me as a lawyer, when already I can show income that precludes him from being my lawyer. And I've pointed out the income thing because I've researched it. I've found the laws for the right to self-represent. And if they want to throw a lawyer at me, then let's start with the net worth finding in total, not just this little partial net worth finding that I could show I make more money than the lawyer is allowed to be representing me under taxpayer dollar. So she is saying that due to odd or bizarre behavior, what? That people have denied me my right to net worth finding, forced this man on me, and I've objected to it, and people just want to do forensics because I've objected to it, and I've got evidence of people trying to force lawyers on me before who have lied before, and now this one is, and this woman, well, obviously, they can't show breach of competence on the record. One. Two, following procedures, they're the ones who are breaking the procedures. These due process rights are my rights. They're to be upheld for me, to protect me from unlawful behavior like theft by extortion, where people don't want to look at judges' signatures and Sims' signatures, and this woman has omitted all of the documents that she got that discuss property. She's just blown them off, saying, dubious, questionable, the authenticity of which is questionable. All right, so this was ordered for no cause, according to this. For this woman, she's saying cause, but according to the record, there is none. And then he's not cooperating at all with the attorney. I don't have to cooperate with an attorney who is not my attorney, who we determined so far still isn't my attorney, if push comes to shove, and who much less is not trying to authenticate documents that this woman is also trying not to ignore. Indeed, has ignored, and tried to take snippets of other documents and turn them upside down. Literally, with malice of thought prevarication. Okay, that's in the first paragraph. Additionally, Mr. Sebastian was referred to this examination because he's not cooperating at all with the attorney. Yet I'm the one that's handing the attorney laws, and I'm the one that's handing the attorney documents, and he's the one who's not authenticating or verifying clearly authenticable documents. He's not picking up the phone. Defendant talks incessantly in court about treason and war crimes and human trafficking and perpetrated against him, etc., perpetrated against him. Well, if I've got evidence of such, and they can be authenticated, and there's property that government got, and they're trying to not call the people who know about it, and there are documents showing that people have signed statements saying there's property, It looks like you've got human trafficking, property, moving people around, lying and slandering. You've also got theft by extortion because all of the criteria are being met. You're oh, I can't read. I've got to look them up to enumerate all seven, but all seven are there to be seen. You're threatening, you're slandering and ridiculing, repute, you're denying defense, all of those things. So, this report is based on a 25-minute interview with the defendant and a review of the order for preliminary screening to determine defendant's competency. Okay, here we have already in the third paragraph, more lies. I've got her taped in a conversation from beginning to end, and it's 18 minutes long. Now, if you put in the night before, which she's not including in this as her 25-minute interview, she might be stretching and trying to say that she is, but it wasn't 25 minutes. And interview with defendant, okay. And review of the order for preliminary screening to determine defendant's competency. We never reviewed the order for preliminary screening to determine the defendant's competency in terms of mental examination, which goes on to deal with, as she shows on the next page, she says that she discussed this stuff with me, rules of law. She didn't. She did say, hold on. Let's move to the next page here. Where's the next page? Let's get to the next page. Oh, that's not it. It jumped around. Okay, I'm hitting stop for a second. Sound recorder. So, I ended the last recording with the bottom of the first page saying that she was lying about the 25-minute interview. It was 18 minutes. And then she goes ahead and says that, and in that interview, we had the interview and we discussed, I forget what it says in the very bottom of the first page, but information sheet, mental information sheet, something or other. Hold on. I can go back and take a quick look because I'm right there now. Okay. So, hold on one second. Okay, where she says, and review of the order, 1 second. Let me get back one little. Okay. This report is based on a 25-minute interview with the defendant and review of the order for preliminary screening to determine defendant's competency, mental examination. And mind you, note the and review, because there was no review. Review of the order for preliminary screening to determine defendant's competency, mental examination. Mental examination information sheet, criminal rule 112, the U.S. Attorney's statement of charges, the Gernstein proffer, and urine drug screening test results. Mr. Sebastian was informed of the nature and purpose of this examination and the limits of confidentiality. So we did discuss some about the limits of confidentiality. As you know, it was really quite well into the interview, as you put it, and there was no mention of any of these other specifics. She said at one point, well, you read something or other. You know about something or other, which in fact I didn't. If that something or other was this stuff. So there was no review. She just made a statement. Anyway, and in the most general of terms, which is not the way it's supposed to be done if there is supposed to be a review of the rules and regs of that kind of interview. And then she's not really asking about questions of dealing with the object and nature of the court proceedings. She was asking about past personal medical history, which she has no real business knowing if it's medical or if it's recreational or any of it, under my right to remain silent. And if I'm doing an estoppel defense, all I have to do is show they're lying through their teeth, and they've been lying through their teeth all along, which I can show. And their credibility is so shot already that, I don't have to testify. Bottom line. And if I'm representing myself, I can ask all the questions I want without having to testify. So here we are with this woman asking me about prior histories of this and that and the other. And I say, there's a record. You look at the record. And I'm perfectly allowed to be irritated when she's asking me about information that is, one, none of her business, two, has no relevancy to who is the judge and who is the lawyer and what is the charge. I was perfectly prepared to let her read the charge and point it out to her on the paper where it was. And in fact, if you look at the beginning of her paper here, she's not even being more specific than what I was in the beginning. Possession of controlled substances. So I was answering her questions. I was giving her information. She has prevaricated time and again. And already in the first page and the first paragraph of the second page, we have total untruths. Relevant background information. Background information was obtained from defendant who, given his mental status, appeared to be a questionable, reliable historian. What did I say that was questionable? A questionably reliable historian. What did I say that was questionable? The documents I gave her were all absolutely verifiable in terms of authenticable, of the authenticity of which can be proven. And, if I can show previous lawyers lying on the record and the record being disappeared, and already in this, it's a question of, are we going to authenticate public documents or not? From prior efforts to slander and destroy and steal, which are trying to be maintained. And then, if I can show where she says, she says questionably reliable historian, period. But what are the questions she has? Mr. Sebastian reported that he is a college graduate and taught martial arts. All that's true. Ran a printing company, true. Took printing classes, true. And there's one class 5 legal certificate, paralegal certificate, that's true. That would be the ethics class. Seems like I got more than any of them. And stated that he's currently employed doing legal rights work. I am employed for my rights, because without rights, no right to work. That's a problem. And mentioned human trafficking and theft by extortion. Well, people have property that they're not acknowledging in their hands that doesn't belong to them, and those same people move me around and try to drug me through lies. That would be trafficking and theft by extortion and poisoning. Psychiatrically, Mr. Sebastian denied currently receiving any outpatient treatment. That's true. Including psychotropic medications, true. He mentioned having been hospitalized in Maryland at some point. Well, yeah, I've been hospitalized for broken bones, and then they carted me off. And there are no grounds for it. In the end, when they say there's no mental illness, what were the grounds? During the admission, and she is not talking about they're saying no mental illness in the sense that no mental illness, and they are talking about property and saying that should be adjudicated. Questionable that. Sims' motion is questionable. Guzman's letter saying there's intellectual property that should be adjudicated is questionable. Rusty's signature saying the government got stuff, DARPA got stuff, is questionable. She, it doesn't fit her narrative, so she just says, forget about it. Call it questionable. And don't mention exactly what it is, which would be asked if she were to be deposed. Okay. So, I mentioned having been hospitalized at some point. During that admission, according to defendant, he received force injections. That's true. And when they say there's no delusions and need no medications and no violent history, and in fact that I'm a nice guy, well, forced injections because they didn't say that at first because they were lying and they had to recant. That's poisoning. Absolutely. During the admission, according to defendant, he received force injection. That's also assault with deadly weapons when they could drop you dead with those drugs and rot out your brains and organs and so on, turn you into a drooling, twitching, half-life thing. Oh, with early termination expected because those are the odds when that shit happens. During the admission, according to defendant, he received force injections, which he described as psychic whatever drugs for psychotic type things, but alleged that this had been done criminally and illegally and stopped. I alleged it had been done criminally and illegally and was stopped. And people still don't want to look at it over with the jury. But the evidence was such that they couldn't maintain the holding in front of decent people. He reported that he was considered delusional, but this was recanted from their assessment. In fact, the final assessment, according to the defendant, was that he was not delusional and did not need... this thing's getting in the way here, so let's push it in further. Does not need medication, I'm sure is what it says. Yep, okay. All right. So next paragraph, Mr. Sebastian reported that he is known to have a drink here and there. Well, yeah, I've been known to have a drink here and there. I was a doorman for a number of years, too. However, he refused to respond to questions regarding recent or current drug use. That was none of her business. Her business was to find out if I understood the object and nature of the court proceeding and could aid in my defense. He indicated that there is no documented drug record for himself since 1986. That's true. He reported a history of substance abuse treatment many, many, many years ago. That's true. That was around 1986. And that comes out to 96, 2006, 2000, that's 30 years ago. Mr. Sebastian has not reported for any urine drug screening test. That's true. Okay. So, is she saying that I'm not cognizant of the role of a judge and of a lawyer, defense lawyer and prosecutor? Is she saying that I'm not cognizant of my rights? I mean, is she saying I'm not cognizant of the object and nature of the court proceedings when it's a misdemeanor trial and carries a year maximum? Is she saying that I'm not able to give the lawyer information that is relevant information, relevant evidence under the relevant evidence rules, dealing with impeachment rules, dealing with prior bad act rules, dealing with state of mind of defendant rules, all kinds of rules that allow this into evidence. Medical records would show all that too, excepting they're savage medical records, and yet they couldn't savage it enough to make any of it stick. I've got people lying and hearing after hearing after hearing, and I can prove each and every one, because lies are hollow and Truth is content. So, prefrontal status examination revealed Mr. Sebastian B. 57 years old. Mental status examination. I told her I was 57 years old. Caucasian male, obviously, who was alert. Yes, I was alert, and I conversed, and I responded. Marginally cooperative. Marginally. I answered, and then she threw a tantrum and said, interview's over, you're out of here. And fully oriented. So I was alert, marginally cooperative, and fully oriented. I knew where I was. He was dressed in appropriate attire, whatever that is, evidenced adequate grooming and hygiene, and maintained appropriate eye contact. His mood became increasingly irritable and hostile when questioned about his charge and use of substances. Well, his charge, no problem. I didn't really want to mention specifics. Didn't really have to if I could tell her what the charge was and where it was on the paper, right? She could read it. And use of substance. I mean, just because she wants to make me spit something out, I don't have to spit something out because she wants to make me spit something out. I spit in the milk when I want to. And use of substance. There was no indication of suicidal or homicidal ideation. Well, that's a good thing because, then they'd have a chance to grab me, right? And, danger yourself, others, and property. If you're a nut. Mr. Sebastian's speech was pressured and his thought processes were coherent. Speech was a little pressured because already they'd been breaching rules of law from the get-go, and I know where this was going, and sure enough, this little woman bit her little apple hook, line, and sinker. Yet tangential and perseverative. Well, yeah, I was making my point, and I was protecting my rights from an invasive woman who was asking information she had no business asking, really. And I had every right to tell her no. And she was asking under standards that she hadn't read the rules to me. Yeah. And I was making sure that I was getting information across to her, and she was being interviewed by the camcorder. You bet she was. So yeah, a little pressured, and thought processes were coherent. Yep, usually are when you're feeling a little pressured. It's like the adrenaline's there, and fight, flight, and you can't fight. So hello, and still be civilized. Unlike some people who lie. And try and murder you, and steal, and not look at property, and not mention stuff that could ruin their little fabrications. Yeah. He repeatedly referred to the federal rules of evidence. Well, you kind of use those in court. The competent stand trial statute, that's kind of some breach of presumption of competence, and his evidence, see court competency. It was nearly impossible to redirect and continue talking. I wanted to get my information into her skull so that she was obligated, duty-bound, to do due diligence. If she had any problems with dubious or questionable, she could have picked up the phone. That was her job. Don't start slandering. Anyway. Nearly impossible to redirect and continue talking. And when people try and make you a burger, you damn straight, you're going to talk over them and you're going to get stuff on the record. Seemingly unaware that he was being asked questions, I answered the questions she was asking, to which he largely did not respond. I answered almost every question that she asked. He did not appear to be distracted by or responding to hallucinations. However, he expressed delusional, persecutory, and grandiosity related to his current criminal case and his psychiatric history. Well, there's persecutory delusions, and it's defined in the Diagnostic Statistical Manual. And it's when a small slight, and you make a big deal out of it, like it's a huge persecution. When people lie in court, when people drug you, when people steal property, that's not a small slight. when you can prove it, it's not a small slight. It's like a persecutory delusion is if, somebody slammed the door on your fingers 2 times by accident, and you think they're out to get you. So, and it's clearly defined in the Diagnostic Statistical Manual, because I've already gone through this persecutory crap. They tried it already. Grandiosity is like if you think you're going to save the world, or some such. Now, if you think you've got a piece of intellectual property that is really needed and can really save people a lot of money and clean up the air, and that might help, do a little bit of value added in, they are documenting disappearing ice caps and disappearing land masses. Well, that could save New York maybe at some point in time. In any case, it would reduce bronchitis, say, if you're talking about, say, an energy system, which this woman read about, come to think of it, signed by my cousin Rusty, saying it would could provide energy for large areas. Of course, she forgot to mention that. So we're not talking grandiosity, or, if it's man on the moon and you're Jules Verne, and you can't show that it can be done, well, maybe it's a little grandiosity. Maybe it's just a little bit of imagination. But if you can show you could get man on the moon, then it's not grandiose. It may be market interesting and grandiose on a market scale. Or say if you've got, a way to... Oh, never mind. I'm just going on here, but the point is made. It's a little wearing talking about people lying. It really does get to be that way. So, grandiosity related to his current criminal case and psychiatric history. Well, I've got 2.5 years worth of they can't explain why they grabbed me on the exit medical record. No cause, except there's intellectual property still missing. Okay, Mr. Sebastian's attention concentration was significantly impaired. I answered every question she had, except in where I clearly was not prepared to answer. And yet she also at the same time says that my thought processes were coherent. She's trying to say that, what is she saying? Attention and concentration were significantly impaired. I was making my statements, getting stuff on the record that she was being given. She was making her statements, which were not accurate in terms of what's being said on her report. And my concentration was significantly impaired. I'm sorry, but she's got to show me that. And, let's see it on the tape. Given his delusions. What delusions? The grandiosity and persecutory? I could show an energy system, date and time stamped. I can show an anti-terror system, date and time stamped, and I've got people who can testify it. Persecutory, I can show people disappeared and tortured me for 2.5 years, and are still persecuting. Not some little delusion lady. So, Mr. Sebastian's attention and concentration were significantly impaired. Given his delusions, it was difficult to assess whether his recent and remote memory were intact. Insight and judgment were considered quite poor. That's the end of page 2. And here's page 3. Hold on. Let me zip back a little. And here we go. Mr. Sebastian brought some, quote, documents, unquote, which he considered, quote, impeachment evidence, unquote, and, quote, evidence that could be used in pretrial proceedings, unquote, regarding his competency. Well, yeah, and it is impeachment evidence, and it is evidence that can and should and is being used in pretrial proceedings, which people are trying to not look at, regarding my competency. That's right. These papers included information on the statute for competency to stand trial in Maryland, the preamble to the Medical Code of Ethics. What are problems with those? You use Maryland laws as it might not be federal rules, but it's supportive, and Maryland rules are pretty much exactly the same as the federal rules in these areas. The preamble of the Medical Code of Ethics, that's right, you're not supposed to be a pawn of government if you're a doctor. And an email that noted his verbal IQ 99 percentile measure means top off the chart. It's top of the chart, not top off the chart. And I can prove that too. No 100 on the scale, yeah, that's true. No higher way to measure, yeah, that's true. According to another email, the defendant was informed that it is unwise to threaten the integrity of the Department of Defense. Well, yeah, that's because I was asking him what happened to my stuff. Mr. Sebastian also provided a document which appeared to be a progress note from 2006 that notes that he is free of any delusional thinking that he requires no psychiatric medications. She forgets to mention upon review. In other words, they were recanting. The authenticity of some of these documents was considered questionable. I guess that would mean the Sims document, the Guzman's document saying that there's intellectual property that needs to be adjudicated, and the rest of the Orr document saying the government got stuff. There may be some others, but just off the top of my head, I guess those are questionable. We can ask her. Well, I just write it. She thought they were questionable. Couldn't she just pick up the phone? Finally, Mr. Sebastian provided a handwritten legal contract on which he requested my signature. It was kind of like a contract. He stated it's for your protection. It was more like a receipt, but it could have been looked at as a legal contract, which, yeah, a receipt. But it was saying that she would factor in the authentic documents, which she's slandering, in her report. And I don't think she factored them in, quite honestly, do you? Anyway, legal contract in which he requested my signature. He states it's for your protection. Well, she wouldn't be charged, quite probably, with perjury in court, conspiracy against rights, an attempt to maintain continuing criminal enterprise in any case, with possible definite coercion, but possible attempted murder by poisoning through lying in wait. Mind you, they would have had to kind of depend, knowing that there was a tape and having received the documents. I don't know if they knew that there was a tape of the documents they received, but they would have to have expected DeMio to waive the evidentiary hearing where I could depose her, which still hasn't happened. Yeah, so conspiracy against rights, her, Hunter, prosecutor, who, she can't say questionable if the prosecutor will hand them in and say authentic, these are authentic public documents. So we've got, anyway, a 4-person conspiracy. There's pretty much no way you can't figure that one out anyway. A jury, I'm sure, would. So, Mr. Sebastian provided a handwritten legal contract and requested my signature. He stated it's for your protection, and had she signed and taken it seriously, she would have been protected. She wouldn't have lied. And it's noted that I received a package of information, which I would then factor such information into my competency assessment. After declining to sign, Mr. Sebastian reported that the contract was on Facebook, so innocuous. Innocuous for those who sign.
Everything I said is absolutely correct.
And for those who have nothing to fear. Mr. Sebastian was aware of his pending charge, which he identified as a misdemeanor. So she said, saying I was aware of the charge. but he refused to identify what substance he was alleged to have possessed at the time. That's not true. I offered to show exactly what it was and identified on paper. I just wasn't prepared to verbalize. This question, along with questions about his current substance abuse, prompted him to become increasingly irritable and hostile and refused to respond to any questions regarding substances. Well, I didn't have to. It really has nothing to do with understanding the object and nature of the court proceeding and being able to work with the lawyer. Thus, given his level of hostility and mental status, the examination was terminated and he left. In other words, she threw him a hissy fit, and because she wasn't getting her way, and I got it all on tape. As he left, he warned me that he had audio taped the interview. I informed her she wanted to call it a warning. Maybe she felt threatened, and if she's writing this, I guess the tape would be threatening if it's seen by a jury. Forensic opinion. Well, yeah, that's so much garbage that it requires no discussion. But that's, you know, right there to be seen. No way it's an honest report. No way it can be seen as an honest report.